Today, I will dictate you from Progressive Magazine February 2024, exercise number 25, legal passage, and exercise number 26, legal passage together. Ready? Start. The Learned Counsel has further argued that reservation is for participation and representation and cannot be used for poverty alleviation. Reservation in public employment is to reverse discrimination and to equalize representation. Providing government jobs cannot pave a way for economic upliftment, whereas other ways of providing subsidies, etc., is a kind of affirmative action to eliminate poverty. Indeed, poverty alleviation is a goal for the state to strive for as per directive principles of state policy, but reservation is not a way to alleviate poverty, as is evident from the statistics that despite decades of reservation in favor of SCs, STs, and OBCs, they are still poor. Relying on the decision of this court in Minerva Mills Limited, it was stated that alleviation of poverty has to be done without trampling on fundamental rights. Welfare steps can be taken under DPSP, but it cannot be done under Article 15 unless there has been discrimination on the grounds mentioned in Article 15(1). As otherwise, the character of Article 15 is changed and results in abrogating the fundamental rights. As reiterated by this court in Indra Sahani case, Article 16(4) has to be in consonance with and in furtherance of Article 16(1). Similarly, Article 16(6) also has to be in furtherance of equality of opportunity under Article 16(1). So, if Article 16 is violative of Article 16(1), it cannot sustain itself in the scheme of the Constitution. Next para. Further relying upon three-judge bench decision of this court in Indra Sahani case, the Learned Counsel has submitted that by providing reservation to forward class, the identity of backward class is erased and therefore such reservation is illegal, hitting at the roots of the Constitution. Moreover, if the forward class becomes backward, it can come under OBC so as to benefit from reservation. She would reason that the 103rd Constitution Amendment is discriminatory to SCs and STs, as the people falling in EWS are approximately 5%, and for these 5% of people 10% of reservation is provided. The Learned Counsel would further submit that the amendment in question is arbitrary too, for there is no mechanism or procedure laid down for it, as under Article 340 for identification of genuine EWS. Learned Counsel has based his submission on the ground that the amendment in question. Next para. Learned Counsel has submitted that this amendment has created two levels of classification. First, between the classes already covered under Article 15(4) and 16(4) and those who were not, which has resulted in caste-based classification. Second, within the forward class, between those who were economically weaker and those who were not, such classification, in his opinion, not only defeats the goal of casteless society as envisaged by the Constituent Assembly, but also attempts to create vertical reservation inside vertical reservation, which is not permitted under the Constitution. The Learned Council has further submitted that, as held by this court in Indra Sahani, if castelessness is an ideal of the Constitution and if this ideal goes into the basic identity of the Constitution, then the constitutional amendment, even if passes the test of equality, violates the basic structure. He has also urged that the condition of adequate representation that controlled Article 16(4) is intentionally excluded from Articles 15(6) and 16(6). Reservation, once starts, has to end. It cannot be in perpetuity. He has further argued that the amendment in question is violative of the Constitution in as much as grant of reservation to already sufficient represented classes while excluding those who were inadequately represented offends not only the equality code but also the principle of fraternity as recognized in the preamble to the Constitution. He has supported his contentions while relying upon decisions of this court. Next para. Learned Counsel has based his submissions on modern jurisprudence, citing academic scholarship to submit that two things are to be considered while dealing with discrimination law. First, the immutability, and second, it should constitute fundamental choice. Relativity of poverty is opposed to immutability. He has further submitted that the 103rd Amendment, in the context of exclusion, made the forward communities as protected group and the backward class as cognate group, which is impermissible. The amendment in question strips of the right of backward class candidates to contest the seats kept in open category to which they are entitled to. The Learned Counsel has argued that this amendment fails the preference test by giving preferential treatment to forward class and taking it away from backward class who are inadequately represented. He has further submitted that the living tree approach should be applied to interpret the Constitution as per the changing circumstances of the society. Learned Counsel has also argued that fundamental rights are individualistic in nature, and while relying on the decision of this court, he would submit that the individual is the focal point because it is only in the realization of individual rights of the class affected. Next para. The Rainbow Papers Limited, of which Ajay Kumar, the appellant before us, was the promoter and managing director, sought loans from a public financial institution, Tourism Finance Corporation of India Limited, and respondent before us. To fulfill its various corporate requirements, the proposal of the company was considered by the respondent and approval was granted for a term loan of rupees 30 crores. In pursuance to the approval, a loan agreement was executed in New Delhi in order to satisfy its obligations under the agreement. The accused company issued post-dated check of rupees 25 lakhs bearing check drawn on Indian Overseas Bank, Kalupur Circle Branch, Railway Pura, Ahmedabad, towards the payment of one of the installments. On the check being presented to the bankers of the respondent, that is HDFC Bank Limited, Nehru Place Branch, New Delhi, the check was returned for the reason account closed. On 19th April 2016, a demand cum legal notice under Section 138 of Negotiable Instruments Act 1881 was issued on behalf of the respondent, calling upon the company as accused number 1 and the appellant herein as accused number 2 to settle the debt advanced by way of corporate loans. Next para. The accused acknowledged their liability to pay the loan amount. The amount was not paid, and thus criminal complaint was filed in the Court of Chief Metropolitan Magistrate, Saket Courts, New Delhi, under Section 190 of the Code of Criminal Procedure 1973, read with Section 138, Section 141, and Section 142 of the NI Act. The complaint was signed and verified by Deputy General Manager within bracket law bracket close of the respondent company. An endeavor for mediation was made but was not successful, and thus the next date was scheduled before the magistrate. In the meantime, a development which took place was that in 2017, Messrs. Neeraj Paper Agency Limited, styling itself as operational creditor, filed an application under Section 9 of the Insolvency and Bankruptcy Code 2016, read with Rule 6 of Insolvency and Bankruptcy Rules 2016, with the request to initiate corporate insolvency resolution process against the accused company, treating it as the corporate debtor. The National Company Law Tribunal admitted the aforesaid insolvency application. The respondent herein filed its claim against the debt which was the subject matter of the NI Act proceedings on next para on 05/06/2018. Committee of Creditors was informed that the respondent herein could not be considered as a secured financial creditor as per definition contained in Section 330 and Section 331 of the IBC. In effect, on legal advice as such, the respondent was opined as an unsecured financial creditor. This resulted in the respondent filing applications in the form of objection before the NCLAT, where the status were sought to be changed from the unsecured to secured financial creditor. Now, turning back to the NIA proceedings, the Metropolitan Magistrate passed an interim order dismissing the application of the appellant for exemption from personal appearance. This, in turn, was predicated on the observations of NCLAT opining that Section 138 of NI Act is a penal provision which empowers the court of competent jurisdiction to pass order of imprisonment or fine which cannot be held to be proceedings or any judgment or degree of money claim. Thus, it would not come within the purview of Section 14 of the IBC, and thus the proceedings under Section 138 of the NI Act 1881 could continue simultaneously. Next para. The appellant thus filed an application for discharge of the complaint case in question herein in the present case, which was dismissed by the Metropolitan Magistrate by the order. The criminal revision petition preferred by the appellant bearing criminal revision also met with a similar fate before the High Court and was dismissed with cost of rupees 20,000 to be paid by the appellant to the respondent. It is this order which is now sought to be assailed before us. Learned counsel sought to urge on behalf of the appellant that the trigger of Section 138 of the NI Act is the non-payment of legally enforceable debt. once the debt is itself extinguished either under Section 31 or in process from Sections 38 to 41 and 54 of IBC, the basis of Section 138 of the NI Act disappears. We may note that these provisions fall under Chapter 3(4) of the IBC. The term debt would mean legally enforceable debt. Under the explanation to Section 138 of the NI Act, and this may be read with Sections 2, 6 of the IBC, it was submitted that the nature of the proceedings under Section 138 of the NI Act is primarily compensatory in nature, and the punitive element is incorporated at enforcing the compensatory provisions under the laws.